How should law on commons be made? And it's a question which is whether law should make society or society should make law on the commons.
I represent an Adivasi Munda tribe community, and I grew up in a village, not from the terms as commons, but you cannot think about a village without the commons.
When we speak about commons in different forums, this text comes up. But at the local level, at the community level, when people are discussing commons, what is the language or the customary language that people will use it?
In 2001, several non-governmental organizations, think tanks, they got together and proposed an international treaty to share genetic commons.
Commons it's a broad word which people understand it in different ways, and you understand it as a philosophy, as an approach, as a way of being, etc. But when you actually ground commons in a particular place, there are rules and regulations, whether it is around land or water or seeds or anything like that, that makes you either an owner or an encroacher. It makes you, it gives you a right or it gives you a duty. So that actually plays out when it comes to commons in different forms. In fact, in legal and policy spaces, you do not really have the word commons. You will have, community forests, or you will have community ponds, or you will have trees, or you will have seed systems. Those are the kinds of things that you will have in different kinds of laws and policies. But you will not have the word commons. So when it comes to intersecting with the question of law and policy and commons, it's very important to see where to locate that commons question. How do people really go and find commons in a legal text or a policy document? How do you actually navigate that space? So I think both in terms of interests that may hamper the future of commons, as well as laws and policies that may enable the future of commons, it will be very useful to actually understand the intersection between laws and commons. Hello, I'm Kanchi Kohli. In this episode, we look at the intersection between law, policy, and the commons, and I have with me today two great speakers, Shalini Bhutani and Johnson Topno. Welcome to the episode on governance of commons, Johnson, Shalini. Such a pleasure to have both of you with great amount of practice behind you. Shalini, you are a legal and policy researcher working on seed and biodiversity. Johnson, you've had great grassroots and policy experience with Adivasi and forest commons. I'm excited to have this conversation and learn so much from your experience and practice, particularly when it comes to questions of commons, and especially the links between commons, law, and policy. Yeah, so my first question actually, as you have been experienced law and policy practitioners, but there must have been some point of time you came across this word commons. What did it do? What was your reaction? And did it actually change the way you started working, or was it in a policy text that you found it, or somewhere else? I mean, your reflections on that.
Yes, I think I'll draw on what I first heard in growing up in a Punjabi household. Not commons, the English word, but an equivalent, which is Sanja. And that was in the context of the Sanja Chula, which is very prevalent in rural Punjab, where the community gathers and has a shared space with very defined roles and responsibilities, where you don't look at caste differences either. And you also make visible the women in the management of that. And so you set up you co-create a space where the resource is shared and also relationships are formed, social interactions happen. But later in law school, when I first heard of commons, it was really through the lens of constitutional law and whether adequately these systems of different kinds of commons have been reflected in the basic legal document of a country and how far it protects them. And while you can see the idea of commons across different sectors, whether it's forests, where the Constitution talks about both capitalism as well as the colonial problems with forests. And you have the fundamental rights and freedoms, which is more a liberal ideology. And then you have the somewhat socialist leanings in the directive principles of state policy, which asks for states to, when they're making policy, to not concentrate natural resources and use them for public good and common good. So commons, when I came to understand, and the different layers of that, along with the work and immersing with different communities that are connected to their commons, if you want to do a short definition, it would really be commons are a shared resource used for public good. But it's also critical to differentiate commons from public goods, because in public goods, you depend on the government for their delivery, whether it's a public hospital or a public school. But when it comes to commons, you rely on communities themselves managing and determining rules for their governance.
So what is your go-to space when it comes to commons? Sanja or Constitution?
I think a mix of both. And to actually see how much the Constitution reflects those social, cultural connects with resources.
Thank you. Johnson?
Yeah. I think to me, being an Adivasi, I represent an Adivasi Munda tribe community. And I grew up in a village. So, I mean, not from the terms as commons, but you cannot think about a village without the commons. And it's a coexistence. So that's how the narratives are. But I grew up understanding commons since 1999 when I started working with Foundation for Ecological Security, working in a place where we have 300 to 400 mm rainfall and the revenue wasteland in the government terms. And that's where the make connections and working around commons, watershed, natural resource management, that understanding grew up. But when I look at Jharkhand, I mean, in general terms I'm talking about, there is no word in the legal text, book, or wherever you can imagine about the terms called commons. But my understanding, commons is something where people thrive on, especially the marginalized communities, landless communities, Adivasi communities. They cannot think about without the commons, and therefore it's more of a collectivization of the resources, which is very, very democratic. So you look at when you find forest, village forest, for example, and very defined rules and regulations have been traditionally being made by the community. How do you govern? If there is a marriage, people come together, they convene, and then how many trees you need to really fell for the marriage, for the firewood. So that's how it is being decided. And what to grow, what not to grow, these kind of things are collectively decided. And apart from that, it's like a worship place for the indigenous communities of Jharkhand. We call it a Sarna, Jaharathan we call it. So that's the place where you connect with the Almighty and respect that. It's a relationship. It's a living commons. It's not a dead commons, that it's a wasteland or it's a grazing land. It's rather, it's more of a common sharing and relationship that you have with it. You coexist. That's how the commons are being looked at it.
Yeah, which I think, Shalini, makes me, takes me to the next question I was thinking of, if you could weigh in on it. That commons actually gives you a sense that, as you explained, it's about many people, multiple actors, all of that. Whereas law and policy is often about dispute between two parties or three parties.
Right.
The parties are very distinct, a set of people. Right. So, I mean, if there is a dispute over the commons, or there's how does law or legal practice really deal with it? And I think if you could illustrate again through a specific example or something like that, where which will help us understand it better.
Yeah, I will. But since we are discussing law, I think the starting point for all law, and I'm just taking India as an example, is the Constitution of India. And as a legal scholar, one read that, and looked out for what are the spaces within the existing constitutional law, which is the ultimate book and source of all other legislation, etc. How is that dealing with the commons? So, and does it provide any guidance, like you asked, about disputes? And it's interesting how, some of the commons that you've mentioned, there are different ideas in the Constitution itself.
True.
One is, looking at the forests as colonial as well as capitalist.
Yes.
Then you have the idea of liberal ideology of the fundamental rights. And then you have the directive principles of state policy. And if you look at Article 39, A, B, and C, it talks about how the state shall, in any policy that it sets up, how does it support men and women equally for livelihood, which means the resources that they depend on also need to be made available and accessible in a management and control system. Second is all the material resources of the community have to be used so that it is for a common good. So that's the first indication of common good coming in. And third, that any economic system should not lead to concentration of the factors of production, right? Which means then you need an imagination on how policy will imbibe these directive principles of state policy. Now, the interesting thing is, while you ask that how does law resolve the dispute? Sometimes law itself can create disputes on who can access the commons and who cannot. Let me give you an example. In the 1980s, the life sciences corporations were developing, and it was seen as an era of biotechnology. And at that time, all the biodiversity, which is, animals, plants, microbes, was seen under an international legal principle called common heritage of mankind. It wasn't even gender sensitive. They was calling common heritage of mankind, not even humankind, which is now evolved. But, and they said, okay, it's a free-for-all situation. The biodiversity are a commons, which means those that have power are able to access it, those who have power in law. And that law was coming through intellectual property rights. The idea that whoever can access it, biodiversity from the biodiversity-rich countries in the south, which would mean a community in Jharkhand, for example, access a local herb, a medicinal herb, get the lead of the associated traditional knowledge on that, which is also a knowledge common, because in the community, nobody's exercising exclusive control that this is only my knowledge or of an individual or a household. But as a collective heritage and the biocultural heritage, which is also the identity of that group. And if a company comes, accesses that without permission, without consent, without sharing any benefits, commercializes, develops a commercial product, like was the case with the basmati rice lines and grains, where a US multinational actually got a patent in 1997 for basmati rice lines and grains. And then that had to be challenged by non-governmental organizations, by even the public sector in India, and saying that, but this is the knowledge commons, and this is basmati rice, which is an identity of our peoples and our small-scale food producers growing here. And therefore, the law itself was becoming a means by which patenting was being allowed, and this access was being allowed. And therefore, law had to adapt to accommodate the cries that were given by the global south that biopiracy is happening. So the concept of biodiversity commons was then changed to national sovereignty, that now governments will have sovereignty. That can be problematic for a local community.
You're right.
Because that can create tensions with the state. Because state interests might not always match with what the local community needs are vis-a-vis a particular biological resource and the associated knowledge. So the disputes can happen at different levels.
Yeah, you've actually used so many, big legal words in any case in terms of sovereignty, biodiversity. So much of the other, which heavy legal text is actually how, when we speak about commons in different forums, this text comes up. But at the local level, at the community level, when people are discussing commons, what is the language or the customary language that people will use it? Are there common words in some senses in the local language that speak to this, or is it a completely different lexicon that people actually use?
Yeah.
Yeah.
So I think the language that we speak, the legal terms and all, so you need a lawyer to really translate that. So it's very difficult to understand the legal terms and all. So like a person like me who have studied, but not from the law background, but still I find it very difficult to understand the language itself. So imagine the communities who are illiterate, but they're very close to the commons. They don't understand the language. How do we bring down, maybe instead of making the community to understand your language, rather than we should come down to them.
But what
so
would
that
they say? What would people say about when somebody is describing a river or something like that, and that it is commonly used? How would somebody actually say it?
I mean, like Jal Jangal Jameen, that's how they talk about it. Like the river, they have a local names and so on. So locally, which has a customary understanding. So they connect, the community connect. And perhaps the legal terms always, as Shalini ji has rightly said, that there is a confusion. It's not that the indigenous community don't like to work, become part of the national development or the national GDP, but maybe the lack of dialogue between the lawmakers and the practitioners and the people actually using it. How do you take it to the understanding? So maybe that dialogue, that understanding needs to be co-created. The another challenge that we have in terms of when we have these policies in making. So I think very less consultation that happen. Who are the people in the team? You don't have the representation also. How do you really make it contextual? India is a vast country and with different ethnic groups, and therefore the contexts are very, very important. Like in Jharkhand, if you look at within Jharkhand, there are 32 tribal communities with different cultural differences, but still they coexist. So one district is different than the other district. So when you make a law or when you make a state rule of how to really translate those rule to the ground implementation, then perhaps it requires a lot of awareness building, lots of capacity building, lots of understanding, so that they understand and then respond and become part of the larger development.
Right. Johnson, I'll pick up from the point you made about how should law on commons be made. And it's a question which is whether law should make society or society should make law on the commons. And again, I refer back to the framework in India, is that even the Constitution of India recognizes that when it comes to maintenance of community assets, those have to be done through a decentralized way. Yeah. And so you have the 73rd, 74th Amendments, which says panchayats and municipalities must do the local self-governance. And therefore, a lot about making laws on how a local resource is to be used, managed, shared. In fact, oftentimes it is Article 243 and its different parts that are referred in this. But there's a very particular one on having a district planning committee, which also talks about coordination between the panchayat and municipalities, so that there is even sharing of commons like water between urban and rural areas. So it's not that you need a separate set of laws for urban and rural areas. You need different management systems depending on the local community, which is dependent on that resource.
Yeah, maybe can I?
Yeah, please.
Like you rightly mentioned, but what I'm trying to put forward is primarily these rules are. The Constitution of India itself is such a wonderful living life, I would say, and the rules, everything that you see is drawn from the Constitution of India. But how do you really translate? That's where the question is. Like for example, like when you talk about Schedule 5 regions of the country,
Can you explain what
Schedule 5 area is? Like the areas where when the Britishers were there, that was the unregulated province, where the British could not have the complete control because of the terrain, the difficulties and all. So that became the Schedule 5 regions, which has a different governance systems. I mean, policy provides that opportunity to really take those. You recognize the existing practices, customary laws that community has, but the translation, who actually translates, who executes, is the bureaucracy and their understanding. Like if you look at Jharkhand, most of the bureaucrats that we see are non-tribal. And PESA or Panchayat extension to schedule area, which provides that any administrator should know about the local language so that you will be able to communicate. So you don't know about how the people, if people are worshipping Sarna, why they are worshipping. So and lots of training also happens to these bureaucrats to really understand. But in practice, we find there is a gap. The another thing is that when you are talking about Schedule 5 area, the village council, the concept of Gram Sabha is such a powerful institution. Like whomever you say, like MLAs, Panchayat, elected bodies, MPs, everybody is elected by the Gram Sabhas.
How would you link Gram Sabha? What is Gram Sabha and how would you link that to commons?
Gram Sabha is a unit wherein, like in the case of Jharkhand, 5 to 7 habitations will be there. They will be governing around 3,000 to 5,000 acres of land, which will have rivers in between, which will have the forest or grazing land and so on. So that's where this community lives in. Now, the PESA or the constitution provides a direct democracy. So each adult member is a member of the Gram Sabha. And each Gram Sabha has each standing committees. Like you have health committee, you have agriculture committee, you have a monitoring committee. It functions like a department. It's like a local government. And it is recognized, PESA recognizes that. But if you look at, they have not been capacitated. They have not been told. So these 18, whoever is the above 18 years, they are honorable members of the Gram Sabha. So they are supposed to be making laws. They are supposed to be talking about commons. They are supposed to be talking about agriculture. They should be talking about seed bank. They will be talking about migration. They will be talking about human time. Whatever that is important for them. And they make the rules and regulations for them to govern. And there are examples where we are working, where we have empowered. We could see that illegal felling of the commons. We have seen there has been mining group coming in and they are protecting it. Because the moment the mining comes in, they will be displaced. So how do you manage that? So lots of work around that. But I think the investment hasn't gone. Like in Jharkhand, we have around good number of Gram Sabhas where civil society is working, where they are trying to empower, we are the government, we are the taxpayers, we need health services, we need agriculture and allied services, and they are questioning today. I mean, this is what we need, supports and all. So regular meeting happening, attendance taking place. And there is a monitoring committee. They are talking about MJ and RAJ, why our payments are being delayed. These are some of the things, but it requires a lot of capacity building. And so that the governance of the commons become more effective. And if government could support, it becomes something very model kind of initiatives.
Yeah. So it's very interesting that both of you are actually taking the conversation so much to the level of decentralization, local self-governments, and relating that to the idea of commons, and which I think we'll come to in much more detail later. But I think what it also gives me, brings me to another question, which Shalini, I'll start with you, and I think Johnson do weigh in on that, is that while both of you are talking about so much of this being at the local, has to be contextualized, it has to be so specific to communities, specific to contexts. But so it's also like decisions of related to commons are often taken so far away from those realities.
Right.
And in that light, I think I want to just, Shalini, if you can weigh in on that, no conversation about the commons and the law is complete unless you speak about that Supreme Court order in the Jakpal Singh case.
That's right.
And if you could actually share a little bit about what is that case?
Yes.
Why did it come up? How is it linked to commons? What did it do? And is it actually even relevant today? Johnson, I don't know whether you've heard of this case, and it will be great if you can also speak in terms of whether it is even relevant in Jharkhand and other places that you've worked. Yeah, so over to you.
The Jakpal Singh case is very important in the conversation of commons, and its relevance today needs to be equally understood. It started when a set of people in a small village in Patiala district in Punjab in the early 2000s encroached upon a village pond. In the revenue records, it was a village pond, which meant it is to be used for the common purposes of the village population there. And so these people started filling it up and constructing over that. The Gram Panchayat did initially raise objections, and then the matter escalated because they didn't relent on the construction. And the matter went up to the collector, and the collector said, no, you can just regularize this and charge them the land rates that have been agreed to for this area. But this didn't go down well with the village communities. Given that a lot of communities also depend on it, those who don't have access to water resources, that their cattle and other activities dependent on water are based on that village pond. And the matter reached the High Court in the Punjab High Court. And that's where the division bench, it went up, in fact, from a single bench to a division bench, and finally came all the way up to the Supreme Court. And that's where Honorable Justices Karju and Mishra, they gave a very critical order in January 2011 saying that this is the time to stop any malpractices and fraudulent takeover of what are village commons, particularly with respect to land, water, etc. And therefore, firstly, they should be restored, revived, and then went on to pass an order saying that all the state governments and union territories must take positive action to try and bring back the commons, recover the commons for the roles that they play in the lives and livelihoods of the village population. I will segue into the findings of the Social, Economic and Caste Census of 2011, the findings of which were released in 2015, which says that over 56% of people living in rural areas do not have land, do not own land, which means they need to depend on these village commons for their livelihood, for their cattle grazing, for agriculture, irrigation as well. And that's why the value of these commons. And as a follow-up to the case, all the state governments and union territories had to explain and give information on what is the status of the designated commons in their villages. And so that's why the potential of this case, even today, given particularly, and in fact, given particularly the climate crisis and the water shortages, because this is very relevant to the water pond being removed from that landscape of the village.
Yeah, I think also just to the point that you were also talking about, the Jakpal Singh case, actually talking about removal of encroachments. And I mean, the highest court of the country actually talks about something like this. But it's also a very generalized order. And in the context of what you were talking about, Johnson, in terms of, at the Gram Sabha level, you're trying to empower Gram Sabhas to take much more responsibility and, leadership in some senses about commons. When an order like this from the highest court comes in, what can transpire in a local context? Because encroachment can mean many things, especially for a whole variety of people who there may not be any title or ownership, etc., that you can prove on a particular place. So, I mean, has there been any conversation about this kind of an order and it having any impact, or?
That's the gap that we feel. Like in the case of Jharkhand, if you look at, um, people are not aware generally about the Supreme Court Bhattigaon Jakpal Singh case. Not aware about it. And if even the larger civil society people they're not talking about it. I don't know about it. I'm hearing for the first time. So how can I imagine a community or Gram Sabha would be knowing about it? Because this is a very historic decision being made or verdict being made, and this should be made aware to the community that there is something that has happened, and it safeguards you. This gives us opportunity to question if there is some encroachment. But in the case of Jharkhand, maybe the encroachment per se, we don't see in the rural areas much. Or might be there because nobody is talking about, so we don't have the data per se. But in the cities you find there are many water bodies have been, encroached upon. There are structures coming up. There are big real estate business coming up. Nobody is talking about it. And even in Ranchi city, which is state capital of Jharkhand, and we see many water bodies have been encroached upon, which has been traditionally tribal dominated, predominantly areas. But we don't see those water bodies now. Nobody is talking about. We should have referred this and then really have that gathering around that and then protect it perhaps. So very distant. We find these verdicts very far from the community practices. That's what I could see. As far as encroachment is concerned, because this provides an opportunity to question and perhaps file more petitions around that and then protect it. Maybe the government of Jharkhand or other states should have the data, how many sites have been encroached upon, and then talk about it. This is very important because this is a common space where it's a recreation, it's a worshipping, it's a cattle drinking water, it's a water harvesting structure, which Shalini ji has already spoken about it. So perhaps these things have to be protected, which nobody is talking about it. In the large mass I'm talking about.
Johnson has raised a very critical point about data. One is, of course, periodically there should be land audits, and those are required. Sometimes the comptroller, auditor general also asks for those to be done, for the panchayat to have the records. But the other thing is the understanding, awareness of what are those customary traditional practices around those commons. For instance, even not only for resident village population, even for migrating pastoralists, the commons play a part, moving from one village to the other. If you don't have data on the number of nomadic pastoralists, in fact, this is the first time in the livestock census of the country that they're also going to do a head count of pastoralists, right? So if you don't know the number of pastoralists and you don't know what their customary practices have been around grazing in common lands in the villages and their migratory routes, then you can't respond with supportive and sensitive laws and policies.
It's interesting the number of things that both of you are actually bringing out. It makes you, when you start with the word commons, you don't realize all these things have so much to do with commons. True. What is that real estate project got to do in an urban area got to do with commons and tribal livelihoods, or what is the livestock census got to do with commons? Those intersections are very important to understand the legal and policy interface with commons, in some senses. I think just using that opportunity, if I have to just there are these two words, commons and common property resources. Is it one and the same thing? Do you think, if you describe commons as common property resources is enough? Or, is it, does it take away something from the commons or whatever? Or maybe it's better for the commons? I don't know. Your reflections on, you would have definitely in your practice come across both these words. And sometimes they may get used interchangeably. Right. But is it the same?
So maybe I look at commons is something overarching. While looking at common property resource, you are talking a term called property, inheriting something. So in my understanding, commons is much beyond that common property resources. Common property is a subset of the commons. That how I look at. Because when you're talking about common property resources, you are monetizing it. You are looking at from the economic, technical terms rather than living commons where people thrive on, especially the people who don't have lands. This is the only space where they depend upon. And to me, it's more a capitalism thinking I look at from that perspective, whereas commons is like it's a life itself. So that's how I look at Shalini. Maybe.
Right. I might differ slightly. Yes, commons is a larger general concept and idea. And it also, in fact, goes beyond natural resources. Like I said, the biodiversity was considered a commons. But now you also talk about knowledge commons, digital commons, which are not based on natural resources. Yeah? But when you talk about common property resources, and I personally, I feel what does more justice is the term common pool resources.
Yeah.
Because the term property complicates the matter even more, as
The
if
term
there,
resource complicates it or no?
it does, but with the limitations of the English language. Even Eleanor Ostrom, who got the Nobel Prize for her work on the commons, she uses the terminology common pool resources, which means these are resources which are pooled.
Yes.
And no individual is asserting property rights on this. But the difference between the commons, which can be a global, wider concept, and CPRs, as they're called, is that with the CPRs, you have a defined geography and a set of institutions, rules, and agreements among the constituent community who are the commoners running the CPRs, that we've come to an agreement on this is how this will be managed and conserved or sustainably used. So there's a little more definition there. There's a little more structure there.
Rather, so would law and policy makers or governments prefer the word property resources, common property resources,
I
or
think
is it
so.
what?
I think it's a more of a common property. They love to have that
because it kind of
there is, you can set the rules who will govern and how it has to be governed. It's more of a technical and governance rules could be framed around the CPR.
Yes, rule making happens at, like we said, at the Gram Sabha level amongst communities through their traditional systems of decision making, at an intergovernmental level as well. Now, let me give you an example. In 2001, several non-governmental organizations, think tanks, particularly in the global north, they got together and proposed an international treaty to share genetic commons.
Now, what is that?
Now, we've talked about large landscapes like forests and water bodies, grazing lands, wastelands, etc. But the very constituent heritable genetic material.
What, DNA or something like that?
Yes, that genes.
Genes.
That makes the plants or an animal or a microorganism, the single unit there, those genes are also being commodified. Right?
Like how?
Right. So you can isolate a gene, trace and track and analyze its constituent characteristics, insert it into another living being. That's what life sciences does, right?
But
so you breed new forms of life.
But why would you want to do that? To make crops or something like that? Or
yes, you can breed new kinds of crops, make them their
kinds.
claim to be climate resilient or drought tolerant, etc. So you are basically constructing or reconstructing life through its ingredient genes. And so earlier, like I said, these genetic resources were treated as a global commons. It was a free-for-all. Everybody was accessing because there were no rules on how they will be accessed. And that's why local communities, indigenous people said, but we don't look at them as resources. We look at them as our biocultural heritage.
Yeah.
We are not breaking it down into their constituent parts. In fact, when they introduce their livestock, they take names, a family in West Bengal, in a village that I went to, they introduce their animal, what in the terminology of animal genetic resources, are introduced as a member of their family with names. So it's the cosmovision of how you look at that genetic resource. And so in 2001, there was a proposal to have a treaty for sharing genetic commons. But why didn't it go through is because governments were saying, but we already have a sovereignty principle. Governments will take decisions. At most, what we will do is we will ask local communities through our national biodiversity legislations on how these genetic resources, which you are calling commons, which have now been commodified through law, how will they be used and regulated?
No, I mean it's almost like it appears like so much of the discussions going on at the I was earlier talking about national, but the global levels is happening in a completely different space and silos, etc. And the word commons seems to be spoken about across board. And I don't know, is there any way is there any need to bridge those silos, or because I think in this conversation we have we've really spoken about the law and policy space, the spectrum of it being from that local village, or rather now from the gene pool of that local village to all the way across global trade. And I mean, who would imagine commons is spoken about across that board? So I mean, do you really think that those conversations need to come together, and how is it that they could come together? Any reflections on that, the two of you? I mean, you could use, I mean, Shalini, your work on seeds, or even your work on indigenous people's rights. I think, Johnson, through those lenses,
Yes.
if you could, speak about this.
Yes, I think local seed keepers in villages run and manage their seed commons, or look at land races and farmers' varieties that they locally grow. It could be a traditional variety of millet, for instance, that they've been growing for as long as they've known it, inheriting that genetic material of that planting of that particular plant or plant variety from their ancestors and all. So those are called land races and folk varieties. But a community seed bank will therefore become a repository where that becomes a seed commons. So anybody locally accessing that seed and planting material does it on rules and regulations that are decided locally there. But globally, seed is now a commodity. It's being traded like a commodity across borders between countries, and you have a large concentrated seed industry. And farmer-saved seeds then become competition. If the farmers don't buy the seed every year and dip into the seed commons, it means companies are able to sell that many less seeds. Therefore, internationally, there is a push to further commodify seed and the seed commons, and to separate out and fragment the physical material of the seed from its knowledge. While communities say are not only the living plant, the seed, but the knowledge about it, how you can grow it, how do you cook with it, what goes well with it, does it have medicinal properties or not. This nature-culture connection has to be seen as a whole.
So what may be happening at the global scale, as you're saying,
Yes.
would that in some way actually restrain the seed commons to continue, or
Yes, because law on seeds has the power to start acculturing you to the idea that seeds is also a private property and not a commonly held resource.
okay,
Yeah. So, I mean, on the global commons and different ideas that we talked about, seed and all. So, based on my working with the communities, I mean, some of the discussion and conversation that we are having very, very important, and we need to engage on those larger conversation, dialogues. But again, there is a gap, how do you take it to the community? Who actually are the stewards of nature when you go further down to a micro level? That's where these languages doesn't reach. And perhaps the communication is something we need to really find out. How do you communicate if there is something happening in COP, and that COP conversation goes into a village called in a remote tribal village, and they are also connected to the larger climate action fraternity. But those conversation needs to be narrow it down. Then only there will be a bottom-up approach to change that will occur. Their participation in implementation of those beautiful plans, beautiful policy brief that we see on the ground. Just for an example, like we work very intensely on the forest commons. Like there are some protected forests, some are sanctuaries, some are tiger reserve. So different categories of it, you know. But in and around, if you look at Jharkhand, we have 32,000 villages, and almost very close to 12 to 13,000 villages are very closely connected with the forest landscape. So you can just, there is a village and then there is a forest around that. And they thrive on, right? And they are actually protecting the forest and all. So if you look at the demography, around 26% are the Adivasi community. And all 14,000 villages are in and around the forest areas, and 29% is the forest cover that we have. And while looking at the Forest Rights Act, which is a very historical act, has been passed by the Parliament, Honorable Parliament, and if you look at the settlement, recognizing the existing practices or ownership over the commons, pre-existing, everything is given back to the Gram Sabha. You manage your forest, everything. But Jharkhand is one of the least performing state in terms of the FRA implementation. And because of that, what happens, like the forest department tells to the community, what's the problem? Why do you need for FRA? Anyway, you are having usufruct rights, you are going and cutting and doing everything. So we are not saying anything. You enjoy like this. Why do you need these papers? So what we are trying to tell that if that's the matter, why don't you recognize their pre-existing rights in a paper? Give them that paper if you don't have any problem, but they don't give. Like if a community has proposed for 200 acres, they will cut 10, so you get a 20 acres. So you are cutting down, these. So how do you manage the commons? So it becomes very difficult at times. Wonderful historical policies have been made, but implementation becomes extremely difficult because the kind of bureaucracy becomes a hurdle in implementation of these, which actually strengthen commons governance. They should have facilitated. Working plans of forest could have been in consonance of the community and forest rights committee, and they could have acted as a technical partner, empowering this community to manage and govern the resources.
So I think from both of you, what you're saying is like, one gets a sense that where law and policy lands can actually make or break the future of commons, actually, and has influenced it in a great deal. So I think bridging that is a very, very crucial point. And I think it's been fantastic talking to you. I'm just actually wondering whether if you both could also just reflect on just final 2 points, actually. One is, if there's one legal and policy question that can really be a win-win for commons, I'm sure there are many. What do you think it could be? And related to that, if there's any place or a person or situation that you could point to where one could actually see this in play, or where one can actually learn or even unlearn certain things,
right.
Will be great. Yeah.
Right. I again will draw onto the seed sector, where my experience has been working with the farmers groups, particularly the International Peasant Movement, and how they articulate what are the challenges of how trade is determining even how commons are looked at in the agriculture and food sector. And just recently, in fact, in September 2025, they came out with a statement saying that we need to look at food not as a commodity, but as commons. Well, what does that mean? How do you unpack that? What does that mean in terms of law and policy? And you said, what is that one thing? I don't think there's just one. There are many dimensions to that. And when it comes to seed commons, the only way other than supportive law and policy is to keep that practice alive. Because if that physical resource and that connection with that seed commons is no longer there, then there's no point asking for supportive law and policy. So continued access to that resource, keeping that conservation of that and practices around it is critical. And there are alternatives to the privatization of seeds and planting material. There is a global coalition of open source seed initiative, just like you have open source software, where the source code is shared and you don't have subscription payment based applications and programs. Drawing from the lessons of that, there have been very interesting ideas of cross-fertilization of commons and keeping them alive from the software sector, from like Creative Commons, from copyleft, not calling it copyright, but copyleft, and taking those ideas into seed systems. So that when you declare that my seed is open source seed, it means the next person can also use it, and provided he or she, as a seed user, seed grower, follows the same ethic of sharing. So you incrementally add to that, you adapt the seed, but you don't claim it as your private property. So you keep that free-flowing thing. So the one fundamental premise of all the commons is breathing life into the ethic of sharing. This is a limited...
it's a collective.
There is a collective. This is a limited planet with we have planetary limits. And there's not enough earth for everybody. And there is no other way out other than sharing. And to make that sharing practical, you need commons-based management and regulation systems.
Thanks.
So I think I'm referring to again Jharkhand experiences, wherein majorly two legal perspectives, which are very, very important, which governs us. One is PESA, although it has not been enacted in terms of the state rules have not been enacted, while we have a model rules by the Government of India. I was in the part of drafts committee, and then we have really made, I'm sure it is going to be enacted soon, but PESA is something very, very important. Panchayat Extended Schedule Area is very, very extremely important because it recognizes the traditional governance systems. That's the provision PESA provides. So all the traditional governance system, customary norms are being factored. And Gram Sabha becomes a very, very important actor to play around, to manage the commons, manage the market, manage the mining, manage the well-being of the community, social protection. So there are end list of things which they can manage. And that power has been entrusted to the Gram Sabha.
If you want to go to a place and see where this is really playing out in Jharkhand somewhere, where you work or somebody else works, and somebody really wants to see it and embed themselves there, what would be that place?
I think FIA Foundation, which I represent today, they have done intensively working with the Gram Sabha, empowering the Gram Sabha. And we have really seen the kind of trajectory that in the way they have been empowered. In Gumla district, there is a village called Lupungpat, which is being inhabited by Asur community. Asur is a vulnerable tribal community groups. And their population is not more than 20,000. And they are found only there. And very important community. And we started working with this community since 2017, and now we see, earlier nobody used to work with this community, and we started working, and now we see change the way they are very empowered Gram Sabha, and they were able to get community forest rights in that area, which is again very important legislation for the community FRA, Forest Rights Act, and they have got community forest rights, and the amount of ownership they have, because now they have a legal right. You have a paper This is my forest. That concept, the moment it comes, it's mine, which was cut, earlier, because there is a forest owned by forest department. Now you are giving back to the community. So the amount of emotional connections is rebuilding with paper with them. And we could see the diversity enhancing. They are able to appropriate the non-timber forest produce. Co-sharing is happening. Rules are being made. How they should really protect the forest. How should they really control the illegal felling, forest fires. So a lot of governance systems and processes are in place. They are also talking about the rivers that flows through, the springs that follows through, how they should be able to manage. So lots of things, good
Convergence
practices are
between
happening.
customary practices and
Yes.
and what is
Yes.
legally now known as community forest rights.
Absolutely,
That's
absolutely. And
interesting.
therefore, maybe when you're talking about commons, maybe tenural arrangement is something extremely important to bring back, which they inherited. And that's where the legality is extremely important. Whatever is available within the country, maybe more dialogue between the legal terms and narratives and community practices. If they come together, commons governance becomes more effectively with much more, ownership and accountability. And with climate change and climate action, it should become a bottom-up approach to be together in this learning.
May I add one point on the paper that you said, that paper document became really important, right, as evidence.
Yes.
I think it's really important to make the point that commons also is about respecting oral cultures. Not everything is documented, right? And so the absence of evidence is not evidence of absence.
Yeah. But because of this oral history, it's good to glorify, maybe. But
those are the limitations of the legal system.
But what has happened is that with oral history, nothing got documented. I tell you one example. When Britishers there are examples. Like, I come from a district where Birsa Munda comes in and Jaipal Singh Munda comes in. Government that time during British regime, they told the community that you say that this forest is yours, this land is yours. What is the evidence that you have? They did not have anything yet. And at that point of time, from Khunti district, they took a big rock,
Placed it
to Calcutta. It comes under the Calcutta presidency, and then to the British ruler, saying that this is our evidence.
Right.
And we call it a Pathal Gadi in Jharkhand. So when somebody dies, they have entire things are being written.
Yes.
And that proves that we existed here since time immemorial, and this is the proof.
Right.
And they had to really go on a walk, such a big rock sheet.
I completely respect that, because the same issue is with the patent laws. That European patent offices and US patent and trademark offices say that we will take patent on your traditional commons. But if you have to give evidence of your prior art that this traditional knowledge exists and our patent should be invalidated, it has to be in writing and documented.
Exactly.
And so they don't recognize oral knowledge
things have
as
changed.
prior art.
Because market has come into place and it becomes very difficult.
Law and policy is ready to be or not to be.
Yeah.
That is the question.
I think we need to collaborate. We have to accommodate each other.
Yes.
No, I think there is a diversity in commons. And to match that, you cannot have one law. There has to be legal pluralism. And the harmonization, standardization, looking at all commons through one lens, through one law, which is happening through international processes, that really is a challenge to the diversities of commons.
Right.
Thank you, both of you. I think what started off as a question about legal and policy abstraction, as you've actually taken us to trying to, almost imagining law and policy through the lens of commons. And how law and policy needs to respond to it, and for that there is a need for a completely different imagination.
Truly.
We may need to work with what we have right now, but to really do a commoning of law and policy, you need a different imagination. So thank you so much for this conversation. It's been a pleasure. and look forward to continuing to work together, and all the best. More power to you guys. Thank you.
Thank you.
Thank you.
Thank you, Kanchi. Thank you, Shalini.
Thank you.
Thank you.
Yeah.